Restoration. Monday. Monday.
Three similar matters, similar cause of action. It was listed before the Lordship. The petitioner prayed for time. Then, my Lord, your Lordship directed not this week. Then not this week listed, my Lord. But it has been listed, my Lord, 129 and onwards. What happened actually, my Lord? I am the respondent, it is true, but I am the petitioner, my Lord, applicant. I have been suffering. And similar issue, kindly consider similar issue, one appointment that has been given, my Lord.
You have mentioned earlier also. You have mentioned. Yes. All the list.
My Lord, see the respondent.
Sorry. All the list.
Due to all the petitioner, my Lord, they have prayed for time. And I have been suffering, my Lord. Kindly consider this aspect, my Lord.
Item number 1.
And one matter, my Lord, actually what happened? They have complied with. Appointment letter has been given. And determination has been changed, my Lord. Since determination has been changed, further, my Lord, application has been filed. Kindly, my Lord, kindly consider.
Yes, you are appearing.
Lordship, in this matter, my learned friend had appeared on the previous day, but his name has not been recorded, Lordship. So that is why
Whose name has been omitted?
Topod Manjo. He's the junior.
In which order? Order of 13-3.
13-3.
Give a slip.
Only his name is.
They are informed that.
I don't know.
They are messing up. Should not happen. Standard. SOPs.
Number 2.
Lordship, I appear for the respondents.
Or in persons.
Now good senses prevailed. He's engaged a lawyer, Lordship.
But on last occasion, Lord, I submitted the supplementary affidavit, and this copy was served upon my learned senior friend's office, and they received the copy of the supplementary affidavit. Lord, according to office, Lord, the delay of the 31 days delay is there. Lord, application for condonation of file giving the explanation for 4 days only. That is why, Lord, the supplementary affidavit was taken out, and that was filed on last occasion before your Lordship's court.
So you have explained another 27 days.
Yes, Lord.
31.
I have given the explanation of the entire 31 days.
That's the only defect, or there is other
Lord, defect, so far as the section 5 is concerned, that is the only defect. And Lord, so far as the petition is concerned, there is some curable and incurable defects that are there. Lord, unless the section 5 is adjudicated, Lord, I cannot take step for the further removal of the some defects.
Section 5 can 1.
Can 1, Lord.
I can win. Number लिखें.
The petitioner was earlier appearing in
এবার next
হ্যাঁ দিয়ে দিচ্ছি ওই দাদাকে দিয়ে
next next এবার কবে এলো? Lordship, the matter is to
After 3 weeks,
Number 3,
My lord, in this matter, I am appearing for the petitioner, my lord. I am led by Mr. S.C. Srivastav, my lord. I am praying, my lord, short pass over, my lord. Let the matter be taken up at 2 p.m., my lord.
every day.
My lord.
Every day.
My lord, at 2 p.m., let the matter be taken up.
No, why? Ask him to come. Matter is at the top of the list and he is not here. Why?
Coming, my lord, just.
Yesterday also it was called.
No, my lord.
But I am for the Union of India.
Let us see what
This is
it
the
is.
first time, my lord.
This is item 3.
Huh?
3 is that?
2012 matter, sorry. Please start. No time.
For
Sorry.
fixation, for fixation of pay, my lord.
Let's see what it is.
My lord, I filed application, representation for fixation of pay, my lord. I was transferred from construction line to open line, my lord. That was not considered, my lord. I am praying, let the representation be considered in accordance with law. I am at present. I am I have been retired on
Against withdrawal of way you are filing a writ
Well,
petition.
my lord. The order here it is. My lord, kindly see. My lord, second. My lord, kindly see second para, my lord, of the order, my lord.
2212 we have withdrawn that way. Why you have filed a writ petition?
My lord, kindly see the second para of the order, my lord. Impugned order, page 15, my lord.
That is, but it has not been dismissed. It has been dismissed as withdrawn. You have withdrawn it.
My lord, it is pertaining to the period of 1182.
Sorry, this is not a case for filing a
The
writ
tribunal
petition.
was not born, my lord.
We don't know. That is not the reason. The reason is you have withdrawn it. All the earlier observations are meaningless. And unnecessarily this matter has been pending now for how many years?
Now,
My God.
now, my lord, may I pray one thing more, my lord?
14 years.
My lord, I am withdrawing this application. My lord, kindly give me liberty to file an application before the authority concerned and direct the authority to
The
dispose of
learned counsel for the
that
petitioner.
application in accordance with law, my lord.
We have
Affidavit of service.
yes, affidavit of service taken on record. Take his appearance. He is appearing.
My lord, liberty be given, my lord, to file a presentation, my lord, and direct them to consider in accordance with law, my lord.
Call the next case.
number 4,
Grateful.
Lordship, I appear for the appellants. Your Lordship, this is pertaining to disability pension of the army personnel. We have served, but the other side is not appearing. May we serve the learned counsel for the respondent who was appearing before the tribunal.
How can you do that? Unless he is appearing, unless he has given the power, that is not a service.
Your Lordship.
That proceeding has ended.
Today it's appearing after, for the first time, it was served in June.
That service on the council will not suffice. He is private respondent, you have to serve on the
Your Lordship.
for effecting service on the respondent.
Number 5,
5, 6, and 7 are analogous matters. Issues are same.
Lordship,
Yes,
Lordship, in this matter, Your Lordship, the issue is that, Your Lordship, the respondents, they were working as inspector in the Central Excise Department. After the Fifth Pay Commission, Your Lordship, they had made an application for upgradation of the revision of their pay scale. Your Lordship, that was considered on 21st of April 2004. But Your Lordship, they had made a prayer for their for the benefits from 1996, Your Lordship. Now, Your Lordship, the upgradation, Your Lordship, the decision, this matter was placed before the Department of Expenditure, Your Lordship, where they have directed us that the post of superintendent, they will be getting their upgradation from the year 2004. Lordship, now I have instruction from the department that the respondents had gone into an appeal before the High Court in Telangana. There were various litigations which is going throughout India, Your Lordship, and in one of the cases, the Telangana High Court has upheld that they would be getting it from the year 1996, which has now been upheld by the Supreme Court, Your Lordship. Lordship, I have the decision of the Supreme Court.
then nothing remains to be
Yes, Your Lordship.
It is with effect from 96 or 97?
96, Your Lordship.
96. No, benefits, actual benefits from January 97.
Yeah, registered 1/1/1996. And certain employees part of railways and Union of India.
Oh, they are only getting from 96.
So, my lord, that notified my lord, income tax inspector, central excise inspectors are similarly notified. But
Where is the High Court judgment?
Yeah.
Which has been upheld? Just give us that. Hmm. Central Board of Direct Taxes, and what is CBIC? Central Board of Indirect
And customs.
Indirect. No, CBIC, what is CBIC?
Indirect taxes, customs.
So this paragraph 24, 25, 26,
Lordship.
para 24, 25, 26. Nothing is remaining then. The petitioner, So the writ order is the same in all
Yes,
the
Your Lordship, for 6 and 7 same.
5, 6, 7.
7.
Hmm.
Number 8.
None appears for the petitioner.
Number 9.
Wait,
I'm for
please, Your
the
Lordship.
respondent here. On the last occasion, I was online, Lordship. Your Lordship inquired me regarding the whether this order passed by the original order passed by the learned tribunal is justified or not. Because by the original order, the learned tribunal has stayed the transfer order. And Your Lordship wanted me to apprise Your Lordship, I have got the judgment of the Honorable Supreme Court in this regard that this before that, I will just demonstrate the facts. Then it would be
Yes,
clear.
that is a better way
Now,
of.
Lordship, what I have challenged here in the latest original application, in which the impugned order is passed, I have challenged the action of non-consideration of my representation, which was given against the transfer order, and which was directed earlier by the Central Administrative Tribunal with the direction that it has to be, my representation has to be considered and a speaking order has to be passed in view of their own policy as well as a Supreme Court judgment. And I have challenged that speaking order before Your Lordship, before the Central Administrative Tribunal. And while considering that, the Central Administrative Tribunal prima facie found that while considering it, the issuing authority, transferring authority, has failed to consider the various aspects which were indicated earlier by the learned tribunal to consider for the purpose of this representation. That is the tenet of my petition, the original application, which is being heard by the Central Administrative Tribunal presently. Now, Lordship, before getting into anything, I want to read the impugned order once. This
Just give us a few facts to begin with. Senior auditor, you were transferred from which place to which place?
From Kolkata to Bangalore.
Bengaluru.
This is in the defense accounts.
Defense account.
Kolkata to Bangalore.
He was-
And my grounds to challenge that was, one is the violation of the seniority. Number two, violation of their own transfer policy, which they have provided. They have provided me the avenue to raise the question regarding the implementation of the transfer.
So transfer from Calcutta to Kolkata to Bengaluru on which date?
My lord, the order dated, transfer order is dated 9/11/2020, 29/11/2024, 29th November. 2024 and transfer the page number. The transfer order will transfer lordship in page number. Lordship, it's in page number 73.
Please ask your client to sit down.
Lordship, in page 73
Yes.
of this petition,
Yes.
Lordship, it will transpire that based upon DAPB recommendations and after approval of the competent authority, the transfer orders of 233 officials is listed.
Page 73.
Page 73 of the writ petition. A2.
The writ petition.
73 na. 10.
Lordship, this is, sorry, my lord, this is 107
Yes.
of the
29.
writ petition.
109, Lordship. 109.
But it appears in mine. So this starts from 107, 109 is part of this document.
So prior to this, if we remember correctly, yesterday we were apprised that prior to this option was called for. 3 options. What was the date on which they called options?
Yes, my lord. Lordship, this was the first order, Lordship. This prior to this, there was no option called for. This is my case. My case is that I challenge this order, and I challenge this order on the basis of the policy framed by them. On the ground of what I can challenge the transfer policy, transfer order. That I
But yesterday you were telling us that you gave an option.
I was given the option exemption. That is there. That is in
So
format.
that is what is the date of that option?
Yes, my lord. It's in
July.
70, page 70 onwards.
Give us the date.
Actual chart.
This is 8 July 2024.
So therefore it was much before. How are you saying you were not given an option before?
So, lordship, this was exemption and retention.
But this was the option wherein
That I have.
so this is much before. You said you were not allowed before.
This was lordship 70.
8/7/24. Where is that? Which page?
Page 104. Now, lordship, kindly come to this choice station, column 13. The first preference, Kolkata. Second preference, exemption requested. Third preference, exemption requested. Lordship, got it? Column 13.
This is a format at annexure A-2. So this must be in pursuant to some
Yes.
provision in the rules or some circular
There was a circular.
requiring such a option to be taken.
Lordship, this was given by them and I have filled it up.
Lordship, page 129.
You are part of the service, you don't know.
Yes, sir. Lordship, one,
Therefore,
two,
we are asking you under which provision
yes,
this
madam,
has been
that is
issued.
129.
129.
129.
13th of June circular.
This is the letter dated 13 June 2024. For
Which
the
is at
preferences. May I read it, Lordship?
Just a minute.
10/21/6131.
This is based on seniority. May I
So there
place
is
it?
no issue of seniority raised by
Lordship,
you.
thereafter.
You come to page 105. On what grounds you have claimed the retention? There is no issue whatsoever of seniority.
No,
You
this
have
is
given
house
5
serving
points.
order of the government of West Bengal.
Hmm?
This is ground mentioned in the certificate is the spouse serving under the government of West Bengal.
No, sir. This is clause 16 is the brief grounds for exemption. In this, you are claiming 5 grounds. One, that you have served 4 years in the Northeast. Second, that your wife is serving. Third, that
Yes.
your father is aged. Report that your son is only 7 years old, your child,
Presently, I am suffering.
and suffering. There is no issue of seniority raised by you.
But this
These
was
are the 5 grounds.
5
raised by
grounds for exemption was applied.
you. Yes. So
This-
therefore, this has
Just
not
there
been
for detail.
considered. According
This-
to you, this has not been considered.
It has not been considered. So far my client is concerned, I have not challenged the order of the transfer. I am ready to be transferred, but within the station, even the within the state of West Bengal.
So it is transfer is not from office to office, it is from station to station.
Station to station.
Therefore, in effect, you don't want to be transferred. Because transfer will be from one station to the other,
Other
not
station.
from one office to the other.
Yes.
Therefore, you don't want to be transferred.
I want to be transferred within the
There
state.
is no such provision. Show that there
Yes,
is
I will
provision.
come.
Yes.
I will come.
Yes.
Now, Lordship, may I place this circular dated 13 June 2024 first
At
in page 129.
yes.
The transfer DAD establishment station organization senior on pro forma strength in respect of AO and staff. Keeping in view the receipt of the large number of transfer requests of AOs and SAS app stall serving the various stations including hard tenure etc. for posting to their choice stations. The competent authority has decided to call for details of the station organization seniors in orders to repatriate, accommodate eligible volunteers and to address the resultant crucial vacancies. It is therefore requested to forward details on prescribed format of all AOs, SAS, app staff serving under your organization, including PIFA, IFA officers, under your pro forma control as per the details mentioned below. Station seniors amongst AOs and for Bhubaneswar, Gaya, Panagarh, Patna, Ramgarh, Ranchi, Siliguri, Jaipur, Jodhpur, Kota, Udaipur, Babina, Lucknow, Varanasi, who are completing 2 years at the station up to 31st July 2024, and for all other stations who are completing 3 years at the station up to 31st July 2024. Organization seniors amongst AOs who are completing 5 years in CDA Patna, PCDA Lucknow, and who are completing 3 years in PCDA Jaipur up to 31st July 2024. Station seniors amongst officials for Begduhi, Bhubaneswar, Darjeeling, Gaya, Kakinada, Patna, Ramgarh, Ranchi, Siliguri, Alwar, Bharatpur, Bikaner, Hisar, Jaipur, Jodhpur, Kota, Suratgarh, Faizabad, Kanpur, Lucknow, Varanasi, who are completing 3 years at this station up to 31st July 2024, and for all other stations who are completing 5 years at this station up to 31st July 2024. Organization seniors amongst officials who are completing 5 years in CDA Patna, PCDA Lucknow, and who are completing 3 years in PCDA Jaipur up to 31st July 2024. The information may be furnished in the annexures circulated vide headquarters circular number such and such dated 8th August 2014, keeping in view the instructions relevant to the respective annexure. In addition to the above, the following additional guidelines may also be kept in view while rendering detail of stations organization seniors. Lordship, so therefore, the information may be furnished in the annexure circulated vide headquarters circular number such and such dated 8/8/2014, which I will be taking your Lordship. It may please be ensured that annexure A2 in respect of each station organization senior must be enclosed duly completed in the respect. Service profile in annexure C in respect of station organization seniors irrespective of command organization along with annexure D indicating the date up to which the transfer is deferred must be attached. Details of station organization senior in Annexure E who were exempted earlier. So there was a clause for exemption that exempted earlier, and details of the station senior seeking exemption in current year may be noted. Now, this was the tenets on the basis of which I have filled up the form and made my representation.
No.
Now,
This is not to you. This is compilation of information from the heads of
The office.
organizations at the various stations.
stations.
This is not for you.
Now, on
This
the
is
basis
their
of which I
internal
was given the
communication.
form,
This is an internal communication.
internal communication,
Yes.
and I have
And this, you see clause 8, it is in explicit in what
Yes.
it intends.
yes,
You
ma'am.
read clause 8 at page 130. They are undertaking this exercise, but it is explicit in clause 8 as to what anyone can expect or claim on the basis of such exercise.
Yes. All the stations organization seniors may please be altered and informed that they are likely to be
Alerted
transferred,
and informed.
Alerted and informed.
alerted, and to be transferred out as per administrative requirement. It is also clarified that they may also be transferred to other than their choice stations
Yes.
as per administrative requirements.
Now let us see what else you want to show.
Now, Lordship, kindly come to page 133 once. This is their transfer policy. And I will be taking your Lordship directly to page 138, clause 8.2. This is for the exemption. Where both the husband and wife are serving in the department, they shall be posted to the same station as administratively possible, keeping in view
Which page?
page
138.
138. But what is the running number? It's not
No, 138.
struck down in my copy. I'm sorry because of this. 8.2, my lord.
Oh. ওইটা দিয়ে দেখবি।
Where both the husband and wife are serving in the department, they shall be posted to the same station as far as administratively possible, keeping in view the spirit of the orders issued by DOPT on the subject. Husband and wife teams, when one of them is serving outside the department, under the other central government department, public sector undertaking, state governments may, as far as possible, and within the constraints of the administrative convenience, as stated above, be considered for posting at the same station, or if there is no vacancy, post in the station to the state where the other spouse is posted. This shall also be governed as per the DOPT's guidelines on the subject as far as administratively feasible. Now, Lordship, kindly come to 12.1. Next page. This is general principles governing inter-command transfer. Transfers. Here your Lordship will find a reflection of that circular, internal communications. Transfer shall also be effected by CGDA's office from time to time to address inter-command stations, shortage from amongst volunteers as well as from organization station seniors as per administrative necessity, and to provide an opportunity to officials to serve in stations of their choice. Such transfer shall be effected through half-yearly transfer exercise in October and April. The main exercise shall be carried out in October, and the volunteers not accommodated in the exercise shall be automatically carried forward to April list. Thus, only fresh request or change request, if any, are to be furnished under the April list. The request not acceded to the April list will not be carried forward to the October list. While furnishing request for October, April, the choice will be the station and not any particular command office. Then 12.2. Such cases shall be forwarded to CGDA's office by the respective controllers along with their recommendations. Where a particular case is not recommended, the reasons for the same should be invariably indicated, failing which the remarks will not be accounted for While considering repartition cases, request from the volunteers, consideration shall be given to the factors such as stay away period from their choice station, whether served before hometown, age, gender, physical disability, and distance from the station of choice. 12.3, where inter-command transfers of the staffs are effected on station seniority basis, effort will be made to post them within the same region, subject to availability of the vacancies. My lord, I am skipping it. I am coming to 12.5. Effort shall be made to give consideration to the experience profile staff while deciding their office of posting. This, however, will be subject to availability of the vacancies. Now, I have already served in outside station for 4 years earlier in 2 places. And then Lordship kindly come to their circular of the Ministry of Personal Public Grievances and Pensions in page 142, where the posting of husband and wife at the same station, that circular is there. And may I please the circular, madam? So far, this person is concerned, already served in 2 places, once in Guwahati, in Assam, and at Tawang, Arunachal Pradesh. Those places were outside the state. Now, Lordship, may I take your Lordship to their office memorandum dated 30th September 2009. May I take place this?
Yeah, we are going through it.
Page 144. Where my wife is concerned, she is a teacher in state of West Bengal. 144, Roman 7, where one spouse is employed under the central government and other spouse is employed under the state government. The spouse employed under the central government may apply for the competent authority, and the competent authority may post the said officer to the station, or if there is no post, that the station to state where the other spouse is posted.
Yes. All right.
Now, my lord, kindly come to the speaking order once.
Yes.
Page 206, which is under challenge in the original application. May I proceed? 206. Whereas in compliance with the direction of the Honorable Tribunal dated 6 December 2024, in original application number 1853 of 2024, the representations dated 3rd December 2024 and treating this original application and part of it have been considered. At the outset, it is intimated that
Let us
employees...
come to paragraph 7. Why do you want to read the history?
And whereas the compliance with the direction of the Honorable Tribunal dated 6 December 2024 in original application number such and such, the undersigned has considered the submissions made by the petitioners, then 1. The service in Defence Account Department entails all India transfer liability. 2. The posted strength of Kolkata station under organization of PCDA Kolkata was comfortable. The administrative requirement at Bangalore station was far greater than that at Kolkata, keeping in view of administrative requirement of all stations, and officials have been transferred to the stations where the staff deficiency is far greater. The transfer on spouse ground is as per administrative feasibility and keeping in view spirit of DOPT's orders, and the same is not absolute. As per para 14 of the transfer policy dated 28/3/2014, the guidelines are meant to guide the exercise of the transfer of staff to the extent administratively feasible. These guidelines are not intended to create any entitlement of any kind. Kolkata, Barakpur, these were the places which I have given later. Kolkata, Barakpur, Ichapur, Kasipur and Damdam are treated as the same station for the transfer purpose. I have no problem if I am posted any of out of these stations. They could have posted me here. I have a problem to go to Bangalore. And this order, though claimed to be the speaking order, remained an unspoken order.
So where is the order passed in OA 1853?
My lord, yes, order of 1853 order is. We order to page check to the paginations are not here, Lordship. I'll just check. Lordship, 1853 order in I have a copy of this. I cannot. লিখে দিতে হবে পেজ নাম্বার গুলো পরিষ্কার নেই না আমার। Lordship, this is 200 in my copy. Lordship, 200 to 201. 202 is the operating portions. Operating portion 203 onwards. In view 10, paragraph 10. In view of above, respondent number 204, the Controller General of Defence Account is directed to consider the representation of the applicant in the light of above-mentioned judgment cited supra, treating the way as per the representation and communicate this decision to the applicant by way of reasoned and speaking order within a period of 4 weeks from the date received a copy of this order. Lordship, in order to do that, Lordship will kindly come to paragraph 5. Learned counsel for the applicant places reliance on the judgment passed in civil appeal number such and such in case of Sheikh Nausad Rahman and others versus Union of India. He also places reliance on the judgment passed by the tribunal in way such and such. He further places the circular issued by the Office of the Controller General of Defence Accounts dated 13/6/2024 and submits that respondents have not followed this said circular. Now these were the grounds taken by me, and thereafter in Learned counsel for the applicant, however, further prays for interim protection of staying of the operation of impugned order of transfer that is such and such. That this order was never challenged by them. by filing the WPC before this court.
Yes.
They accepted the decision of the CAT to consider this representation in the view of this. And now they have disposed of my application, and that is the tenet of the challenge in the way 106. Now there are three folds, Lordship. There is a violation of the seniority. There is now it appears non-consideration of the grounds taken by me.
No, there is no issue of seniority.
Lordship, so far this is an internal communication, but it's a question of law. They
There
should
is
have
no
been
question of seniority.
Lordship, I have
Neither you have raised, nor before the tribunal, nor in your representation, nowhere.
there is an abatement in the original way, Lordship. May I?
Now in the second way, you may make that
No,
affirmation.
the first way, Lordship. The second way.
Let us see.
In the second way, Lordship.
No, second way is your right for consideration crystallized by order passed in the first way.
Yes,
So therefore, if there is no issue raised in the first way, it cannot be open-ended that every stage you will come up with a new ground. So we have to confine it to whatever was directed in the first way.
first way.
So the direction was to consider regarding state and central government employees, if they are spouses, how it is to be done. The 2009 memorandum that you have relied upon,
And 14
30th
memo.
September,
Yes.
and the other
And
one is
2014 memo
2014 one. Yes,
guidelines.
these are the
Now,
two.
I
things.
say, Lordship, this should have been considered. Now, Lordship,
And plus, perhaps you have raised a ground that whether the CGDA was required to.
consider it, whether they have the delegation or not.
Yes.
Because the now, Lordship, one thing, Lordship, your Lordship asked me yesterday that whether we can challenge it by the transfer order, whether it can be challenged. Lordship, so far, the last the judgment of the Honorable Supreme Court, that is,
We did not, and we cannot make such a query. We did not, and we cannot make such a query that whether you can challenge. Why can't you challenge?
I can.
Who will ever think that you cannot
I
challenge?
can challenge it. If it
We
is
said that without complying with the order,
yes.
whether it is open to a person to challenge in view of the settled law now.
But now I am protected by the orders. I am protected by CAT, and that is
That
not
we have
state.
seen there. Yes.
They have challenged it here. Now they have not challenged that particular
Correct.
order.
You are correct. We have seen that.
But
In fact, the tribunal, we don't know how, but has asked the respondents to continue an interim order even though the final order has been passed.
Right.
But it has been accepted by them. They have acted in purported compliance there. Therefore, now that is an order that is, whatever it is, it has sustained finality inter partes. We don't intend to upset that.
Right.
But then whether 2014 and 2019 policy gives you an indefeasible right, that is the issue.
that is to be decided by the learned tribunal. Now, Lordship, another aspect. This is my reading, and Lordship, one thing I found.
Because there is by now there are judgments, you must be aware. We don't know whether you have come with the judgments, that what is the effect of such guidelines, circulars, how far they are binding, how far they create a right in the employee.
This has to be argued.
These are issues. No, you have to satisfy us because we are examining the issue.
Only thing is that
Yes,
the learned tribunal may submit this.
because it's a transfer
Now,
after
they
all
have come against an interim order. And
in
they are
these
seeking-
proceedings.
Yes. This is an interim order is under challenge. And they are seeking a declaration which will upset the entire thing. Lordship, kindly come to their prayer. A declaration in page 31. That impugned order dated 28/1/2025 passed by the learned Central Administrative Tribunal in way number 106 of 2025 by the learned Central Administrative Tribunal Kolkata bench is bad and perverse in law. And that is an interim order.
Therefore, now that the order has been complied by them, whether good or bad, that is a different thing. Once
Order
they
has
have-
not been complied. Order has not been complied
they
by
have not
them.
disposed of your representation.
They have now that was representation was disposed of in terms of the earlier way. The order passed in the earlier way.
Correct.
Now I have challenged that in that matter, Lordship, the learned tribunal was pleased to pass an order, interim order.
Therefore, in the matter of a transfer, even after consideration whether a stay should be passed, upsetting the entire chain transfers, We
Now-
all know that these transfers have cascading effects.
So Lordship,
There are many people who are to come in your place. You have to go somewhere. They have to be relieved.
No.
Entire thing is to be stalled for one person
Lordship,
because he is not getting a choice station.
Lordship, the only thing is
So
that
the law, let us see the law. We have
No.
seen the facts. What
No.
is the basis of your claim?
now, Lordship,
Two circulars, 2009 and 2014.
these two circulars are the
Now in view
foundation.
of, huh?
These are the foundations of my claim.
Now let
Now,
us see
Lordship,
what
one
is the
thing
legal
that
position.
Asking this question to myself, Lordship, if today your Lordship decides the entire lease is pending before the learned tribunal, if it is decided today, it will amount to the passing of a decision of the final decision.
Therefore, we'll consider what order we have to pass. Let's see the law. Let us see the law whether without complying with the transfer order, you challenged it. Once the tribunal asked them to consider, they have considered, passed the order. Again, you are challenging it. So there should be a stay for years together in a transfer matter. And the employee should not be directed
But
that
if
you
there is an
join and then you contest.
There is an order of resumption also. The learned tribunal has
That
directed
is under-
Whatever, that
you
we'll
in that
consider.
particular post.
First of all, your right has to be seen. You are an employee, you are a government servant.
Now, Lordship,
You
the
are
only thing
questioning
is
the
that-
authorities' power to transfer, the discretion to transfer,
No,
and you are doing it without complying with the
I
transfer.
am not.
So that is
subject
one
to
issue that
correction,
will
subject
stare
to
in your face. Therefore, we are
Yes, well,
observing this.
subject to correction, Lordship, that I am not challenging the authorities' power to transfer.
Oh, yes, you are.
I'm
That
challenging
is your challenge in the first way, which is continuing till date.
authorities' power.
Ultimately, it is the issue whether they can transfer you in this way or not. That is the issue.
I'm challenging the
That
power
is-
has to be exercised.
So
in a
therefore,
just, fair
whether
manner.
they can transfer you like this or not, that is the issue.
Now, one judgment, Lordship, I
And
got-
for such a transfer or for such a issue, a stay should be granted.
Lordship, in this judgment, Lordship, may I hand over the Nausad Rahman.
এটা annex করা তো না? Citation টা annex করাটা তো? Annex
আছে কিন্তু এই কপিটা সাইটেশনটা 2022 এসসিসি
Yes.
আমাকে রমা কপিটা জানবো the circular guidelines was considered. I will directly come after the analysis to the ratio. Paragraph.
Just wait.
Yes, ma'am. para 54 onwards. Lordship. Here the question was whether the modification of the policy is required to be interfered by the court. And the Supreme Court concluded, in considering whether the modification of the policy is necessary, they must bear in mind of the need of a proportional relationship between the objects of the policy and means which are adopted and implemented. The policy above all has to fulfill the test of legitimacy, suitability, necessity of the balancing of values which underline decision-making process informed by the constitutional values. Hence, while we uphold the
We
judgment,
told you we are trying to read.
Fine.
If you're reading, can we even understand what you're reading? What is the point? The Supreme Court has said by taking a policy, you please consider. Yes. So the Supreme Court appears not to have interfered or to pass any direction granting ICT to anyone. It said it is the policy, and whenever you revisit, you consider these things.
no, this is I'm seeking their own policy to be implemented. There, the policy was sought to be modified. Supreme Court refused to interfere.
Therefore, we are saying how this will apply to this case.
No.
Here, the rule did not contemplate, rule contemplated cadres to be within the commissioner. People were going on ICT on the ground of spouse and these things, family life being upset.
Consider in view
Therefore,
of-
the government said that no, this cannot be done. This upsets everything. They cannot be absorbed in another commissionerate
no, government,
because the cadre is within the commissioners.
no, Lordship, the only thing is that the government can say this, but provided
They approached the
government
Supreme
gives
Court
the
saying
reason.
that no, there is a policy that wife and husband should be posted together. Supreme Court said, but here the rule is otherwise. ICT cannot be done. But the Supreme Court directed that it may be revisited and these issues may be considered.
that there was no policy in this case. In my case,
Oh,
there
there
is a
was a
policy.
policy. The same policy that you are relying upon.
yes,
The same policy that you are relying upon.
yes, 2014
The
policy.
petitioners therein were also relying upon the same policy.
So that policy is there. I am not seeking any modification of that policy.
No,
Kindly
no,
come
but
to-
the Supreme Court did not recognize the rights to
Lordship,
be
kindly come to this.
given the benefit of ICT because of this policy.
Kindly come to paragraph 54 once.
Yes,
Paragraph 53 onwards, the state interference in the rights of privacy, dignity, and family life.
That is why we are saying it has said many things, but ultimately in 56 it has said it will consider, they will revisit,
No.
and they may consider.
The policy has to
There
be
is no law laid down, there is no direction given.
Lordship, kindly come to this once. Kindly, for my satisfaction. Lordship,
We have seen 44, 54, 55, 56.
yes, my lord.
all.
I want to just demonstrate what is this, what was the lease about here?
The obiter that you are relying upon, what is the ultimate analysis? You see,
The ultimate analysis is that the
is that we
decision,
will not do anything. Let them revisit and reconsider, keeping these issues in mind.
no, Lordship, the only thing is that
If the court
have
were
they
to
visited-
realize that this gave a right in favor of the employee, the Supreme Court
Lordship,
would
the
have
question is
interfered.
that have this speaking order says anything that they have visited my issue?
That is another issue that we have not argued till now.
That is,
We were wondering why you have not argued this issue.
yes, I have come to this, that
Therefore, that is another
that has
issue
been
that we have
visited,
seen.
Lord.
The consideration we have seen, but that you have not argued. You are on these issues. Law is very well settled.
Yes.
There's not much to be
No, Lordship, the only thing I
considered
want
whether
to
you have a right or not.
says, once there is a policy, it has to be.
It
is
does not. There is no judgment that says that these policies have to be implemented. Let us see one judgment. It is that these are guidelines. They themselves say subject to feasibility, subject to availability. No employee can claim a right. In your case, the issue is there was a direction, whether there is compliance or not, that is the only issue. Because they chose not to challenge that.
Yes.
And it has attained finality inter parties.
Whether they can.
That is the only issue.
So
There is no enforceability of these policies.
Only one thing I want to framing of transfer policy in all cadres of posting husband and wife at the same station. This was issued dated 24th November 2022. Here I want to only refer to one, then I'll hand over. It says that complaints are sometimes received that even if the posts are available in the station for posting of the spouse, the administrative authorities do not
Therefore,
accommodate.
ultimately, the ultimate thing is why they have not considered.
In the light of those. That's
Therefore,
that
that
is
is
something.
the only issue whether they have considered properly or not.
Yes,
In terms of the earlier OA.
yes,
What will be the result of that consideration? We don't know.
Hmm.
And we are not here to direct them to.
my lord. I have also not seen.
Or to say that you must take a decision in favor of the petitioner.
No, no,
That
no,
is
I
for
couldn't
them.
say that.
So why they have not, why the concerned authority who was directed has not taken, and why the authority who has taken has not taken into consideration the two policies which the tribunal directed. This
Yes.
is the main issue.
My lord.
Yes. Yes. Why? Why a different officer has considered?
Lordship, that has also been explained, Lordship.
No, what is the explanation?
Yes,
When there is a direction and you choose not to challenge the direction, why should you not comply?
Lordship, it has.
And the consideration is very cryptic. There is
Lordship,
nothing.
in the consideration, Lordship, it has been stated.
Let us see what it says about this spouse policy.
Spouse ground, Lordship.
Let us see. Where is that?
Lordship, paragraph 7, subparagraph 4.
Yes.
Lordship, the transfer on spouse ground is as per administrative feasibility. And keeping in view the spirit of the DOP and T orders, the same is not absolute.
That is not what you are required to consider. You are required to consider whether there is any scope for accommodating this request or not.
Lordship,
Nobody asked you to say whether it is binding or not.
Lordship, if
It amounts to, in a way, reviewing the order passed by the tribunal, by the authority, and that also an authority who was not directed to take a decision. Why this authority has passed the order?
Lordship, here what has happened, Lordship, it is it was passed with the approval of the authority who has taken the decision, Lordship. I have, if your Lordship comes to page 251.
Madam,
Lordship,
please read paragraph 8.
Lordship.
The consideration is by the undersigned.
Audited, it was carefully considering the representation in the light of the transfer policy, facts and circumstances of the case is considered and is administratively not.
The undersigned after carefully considering.
Now, therefore, in pursuance of the directions of the Honorable Tribunal, the order dated the undersigned after carefully considering the representation.
How?
Lordship,
You cannot frustrate an order which you choose not to challenge. Or are you so big that the tribunal's order is not
Lordship, what is
to be honored by you?
Lordship, it's not a question of not honoring lordship.
That's
There
why we are
certain-
trying to ascertain what is the issue.
Lordship, here,
Either you choose the order or to challenge the order, now you comply with the order.
lordship, that
So what
order,
what the tribunal can do? And you are assailing an interim order.
lordship, this is an, yes, this is an interim order, lordship, but the
What
order,
prevents you from even now complying with the order and telling the tribunal that, look, now the competent authority has considered it?
lordship, the competent authority has considered, lordship, lordship, let me take your lordship to page 251.
Page?
251, lordship. Lordship, this is the explanation, lordship.
No, no, no. We are not asking for any explanation. This is
Let-
no
it
consider.
was
This is again by the same
that-
authority.
No,
This is again by the same authority.
but issued with the approval of the CGTA.
That will not validate, that will not ratify.
It has been duly designated and the decision was conveyed by the undersigned by speaking order on behalf of the CGTA. That is,
Who gives you the authority to consider on behalf of? And who gave him the authority to delegate without seeking a modification of the tribunal's order?
lordship, that, that was, this is the CGTA had given the
Sorry,
authority.
we don't find any force in your submission. We don't want to express much on this because it is still before the tribunal. But we draw a very bad inference.
Then lordship will, then in that event, lordship, because
You have precipitated this. All you are required to do is pass a reasoned and speaking order.
lordship, that
For
has,
some reason you have not done it. Now you issue a letter in January 25 that I have delegated or it was delegated. Who
It was-
gave
it
you
was-
the authority to delegate? Or could you have done that without getting a modification
No,
of the tribunal's
lordship,
order?
lordship, that, lordship, it is a place where it cannot be improved, lordship. But what I was just trying to, lordship will kindly see the analysis, the ratio of the decision relied upon by my learned friend.
We are not going to go into it. It remains to be considered. We were only seeing whether the
Lordship,
interim order is required to be interfered or not.
lordship will kindly give us the opportunity to reconsider the matter in all the details.
You go before the tribunal, you ask the tribunal who is stopping you.
Then lordship will kindly give us that opportunity.
You may give, yes, we'll give you
Good.
the long and short of the arguments.
Item number 10.
Only point here.
Item 10, I appear for the petition. That is a matter. একটাই আছে আপনাদের। But it's a matter of compassionate appointment.
Where is the 4/11/22 notification?
But 4/11/22.
That appears to be the main consideration.
Yes. But it kind of turns to page 77 to 82.
77.
Hmm.
This is the 4/11/22 one. No, this is 16 one.
Just 80.
80. So what does it say now?
Well, the kindly turns to the clause 1, Millet.
Yes.
Clause 1D. Married daughter who on the date of death or incapacitation was unmarried. Now this was the existing provision. Now the proposed provision is C. Daughter including legally adopted daughter before the death or incapacitation or missing. Well, the daughter. The word is now daughter. Including legally adopted daughter before death or incapacitation or missing. So, but the married word has been expunged. But this has been done after the special bench judgment of this court. Married word has been struck down by the special bench.
Yes. Now how it will apply to you?
Well, I tell your lordship, why? Well, my father.
It has come into effect on 5/11/22.
Yes.
And what is the date of your father's death?
11th of September 2008.
8.
Yes.
Then how?
I tell you. But the original application was filed. Kindly have looked at the original application was filed in 2014. After the rescinded order was passed, page 46. Before the rescinded order, at least your lordship kindly turns to page 39 once, where the delay caused. Page 39. I got it. The date is 16th of December 2011. They called me for personal hearing after 3 years. For the first time. This continued. Now, your lordship turns to page 46. It was rejected for the first time on 10th of April 2014.
Page 49. Page 49.
So this 46 was challenged by you in the OA.
Yes. In 2014 itself.
Yes.
Now, but they have said that I failed to comply with the conditions as laid down in paragraph 3D and 10A of the Labor Department notification dated 251 EMP. Now, kindly consider what is 251 EMP.
এটা কোথায়? পাঁচটা কোথায়?
3D.
Three 1213.
I have the book.
We have got it, don't worry. The compassion.
Yes, 2013. Joseph, ke egi dine? 251 EMP dated 3rd of December 2013. That I think this book will suffice everything. All the notifications are in this book.
Just copy of this. There are two copies. There are two copies. 3D.
Now, the interesting part is, when this is a 2013 notification. My father expired in 2008.
Yes.
Now, the government has said,
So in 2008 you were eligible.
no, married daughter. Now, all the notifications which were prevailing at that point of time has been given a go by this scheme of compassionate appointment in 2013.
Correct.
Yes. So, I have to be governed by this 2013. Now, got it? That notification?
Yes, we have got it.
3D.
Yes.
Married daughter who, on the date of death or incapacitation, was unmarried.
That has been taken note of in the 22 notification itself.
Yes.
In the table, it has been repeated.
Now, the married daughter, the married portion has been omitted.
Yes.
Now,
No,
your lordship,
But this 3D has been quoted in that notification,
Yes.
which you have just read a while ago
Yes.
at page 80, I think.
But may I only harp on the second point?
Yes.
Because on two issues, on two counts, my case was rejected.
10A.
10A. If the family of the deceased or the employee retired on being not needed, is in need of financial assistance and the same is absolutely necessary to support the family, the application for employment is to be submitted within 6 months from the date of death or retirement on permanent incapacitation. If no application is submitted within the said period, it will be presumed that the family does not require any financial assistance. If no application is submitted after the expiry of the period, will be entertained.
That is not relevant. Even if we ignore that, you still whether you will be eligible, that is an issue.
I'm grateful to you, Lordship.
So
I'm so
3D,
grateful to
3D is
Only-
staring in your face.
Absolutely. Number one, if I overcome that, then I'll be through for employment. Number one, your Lordship, kindly have a look to these special bench judgment ones.
No, no, no. That judgment is not to be seen by us. That judgment is something for the state to consider. That state has considered. That policy has come out in 22. Below the table, there is one line. Read what it says. Just below the table at the notification of at page 80.
Page 80, yes.
Just below the table, one line.
This notification shall come into force with immediate effect.
Immediately.
True.
There is no retrospectivity.
True.
Or it could have been, but it is not.
But here also I have a case.
Yes. So let us consider that aspect.
I'm grateful.
Yes.
Number one, kindly have a look to the provision of law, my lord, which was considered by this honorable special bench in this.
No, no, sir.
But
That we are not going to.
Kind
That will be not, that will be a pointless exercise.
It will not be. My lord, kindly,
It will
kindly.
be, it will be, it will be. The notification has to be read as it is. The notification is not under challenge.
But the notification was under challenge before the special bench.
No, no, it is not under challenge. We are not the special bench. We are not hearing that matter. We are not going to consider that matter in any way. In these proceedings, the 22 notification is not under challenge.
No, no.
That notification is in compliance of the special bench judgment. The notification in unambiguous terms says it is applicable from the date of its notification in the Gazette. And otherwise also under the General Clauses Act, it would be applicable from the date of its issuance in the State Gazette. Now, can it be extended to a claim being considered in 14?
Yes.
That is the only issue.
But yes.
Even when the special bench judgment had not come into existence.
Absolutely true. But I tell you, Lordship, but kindly give me 3-4 minutes time.
We have already given you more than 5 minutes.
I'm so grateful.
Yes.
Now, the special bench was considered by two of the honorable division bench of one of Justice Harish Tandon.
Yes.
And one of Justice Velumani's division bench. But I will demonstrate.
Yes.
But your Lordship kindly allows me to demonstrate the order of the division of the special bench once and the two division benches.
Before Honorable Justice Velumani, the case was considered in 23. In her case, in the case which her ladyship has considered.
But your Lordship kindly have a look to Justice Velumani's judgment once.
Yes, come to it.
But before that, kindly turns to page 143 once, for my satisfaction.
Yes.
This is an judgment
Yes.
passed on November 21, 2022,
Correct.
presided over by Justice Tandon.
Yes, yes.
Yes. My lord kindly turns to page 144. Last paragraph, admittedly.
যাও করতে পারো না যাও যাও এখানে দাঁড়িয়ে থাকো না লজ্জা লাগে না
Yes.
Now, my lord, I will take your lordship to page 153 of the judgment delivered by Justice Velumani's division bench on this point.
No,
Kindly have it.
you are asking us to see the earlier judgment.
Yes, the Justice Tendon's judgment, my lord, has just now read,
Yes.
and Justice Velumani, my lord, page 150 onwards, my lord, took a similar view on this. My lord, the operative part starts from 154. Sorry, 153, last paragraph. It is an admitted fact. Last paragraph.
No, in both these cases, the tribunal has directed to consider in light of the special bench judgment. These matters were decided in light of the special bench judgment
No,
because
in this matter, not. My case was rejected earlier in 2014 when special bench judgment was not there.
both the cases that you are relying upon,
Mm.
the tribunal directed for considering in light of the special bench.
No,
judgment.
no.
No.
Let the,
Now come to page 146.
146.
Yes. The first rejection was on the ground that read from there at the top.
Yes, the first rejection was on the ground that the married daughter who was not unmarried at the time of death of the government employee cannot be brought within the ambit of dependent family member under the aforesaid scheme. The said decision was challenged by the petitioner in West One before the tribunal, and tribunal, after noticing the judgment of the special bench rendered in the aforesaid case, directed the secretary of the health department to consider the case of
So
the
now no becomes a yes in this case. Now come to page 151,
151.
the other case. Here also your no will become a yes at the top.
Yes. Now, my lord,
The appellant challenged the order by filing a writ petition. This court by order dated so and so considered the judgment of the special bench of this court wherein the word unmarried was struck down as violative and therefore directed for set aside the order and directed to consider the claim of the respondent taking into consideration order of the special bench. In both these cases, there was an order for consideration in light of the special bench judgment which had come into existence while the matter was being considered. Thereafter, it has been rejected by saying that it will not apply. So the court has said, no, there was a direction. You are required to comply. We will not hear this system.
my lord, not only that, my lord, I request
Therefore,
your lordship.
when you say no, please read before you say no. We will not observe something unless we have found it. And that also factually.
Absolutely.
Yes.
Now, my lord, I request your lordship, my lord,
So these two judgments are factually at variance with your case. Now, your case, the consideration was in 2014. The tribunal order is of which date?
2025.
25. There is no issue regarding this. There is no such direction given that it has to be considered in light of the special bench judgment.
Tribunal has dismissed my case,
Correct.
where, my lord, in spite of the fact that the special bench judgment was, my lord, was in the field. Now, my lord, kindly, I request your lordship, my lord, to.
This judgment is even after the amendment. Forget about special bench.
This judgment has come after the amendment, and the
Yes,
judgment
the
of the tribunal
is after the amendment.
Yes. And my lord, the judgment has not considered the amendment. Your lordship, kindly have a look to Justice Velumani's judgment
So we are
once.
considering. We are considering.
Now, your lordship, kindly have a look to
Yes.
my lord, page 153,
Yes.
last paragraph. My lord, for your lordship satisfaction, my lord, may I read? It is an admitted fact that the appellant was married on the date when her father died on, my lord, 21st of September 2013 while in service. The special bench judgment was not born on that day. Her mother made her first application in 2014. The first application was rejected on the ground that married daughter is not eligible. Whether married daughter is eligible for compulsory appointment or not was considered by the special bench in 2015. Paragraph 113, it is held. Consequently, the offending provision in the notification dated April 2, 2008 governing the case of so-and-so, and February 3, 2009, governing the case of Purnima, that is adjective unmarried before the daughter, is struck down as violative to the constitution. It, however, goes without saying that after the need for compassionate appointment is established in accordance with law, with the laid down formula, which in itself is quite stringent, a daughter who is married on the date of the concerned government employee while in service must succeed in her claim of being entirely dependent on the earning of her father, mother, government employee on the date of his or her death, and agreed to look after the other family members of the deceased if the claim is to be considered further. Now, Malad, I have a case here. And on that, as per the-
You have skipped the last paragraph at page 154.
I'm reading that. I'm reading that. As per the above judgment, the married daughter is also eligible for compassionate appointment if she is satisfied that she is dependent on the deceased employee. In view of the said judgment, this court orders so and so, so and so.
No,
Now-
in view of this court has already set aside and directed for fresh consideration
Yes,
in light of the,
absolutely. Malad,
there is
this
no
has-
such fact here.
Now, Malad, I tell you, Lordship, Malad, I have Malad, something to place it before the court. Malad, your Lordship, kindly have a look to page 62. Page 62. This is a letter of 12th of October.
And what is the date on which you made the application for compassionate appointment?
Malad, the date is just first application was made page 34 onwards with the prescribed format. 15th of September 2010.
15th of September,
2010. Page 37.
15 September 2010.
Yes.
And what is the date of death?
The date of death is
2008.
11 September 2008.
Page 49, if your lordship can see,
I-
particulars are there.
I will.
In our-
I will.
Oh, 2 years.
But that is not. But the department has refused to accept my case. The papers that I have mentioned. My lord, kindly have a look to page 71. This is the letter in Bengali. My lord, Justice Bhattacharya is there, my lord, to assist your lordship. It was made in 4th of February 2009. In spite of last paragraph, in spite of filling the prescribed form, the department, the BDO office has refused to accept it.
Page?
71, 72.
What is this?
72 is, these pages are in Bengali.
No. What is the date of this document?
Yes, 4th of February
2009.
2009. The receiving seal is there.
And this is enclosed with what?
This is the application I made before the block development officer that the office of the BDO is not accepting my prescribed form in 2009, before 2 years.
September 2000.
Huh?
Can you see page 49? 15 September 2010.
2010 is the date when I filed, I was allowed by the department to file the prescribed format.
Where have you set this in your OA? Let us see.
Can you see our reply?
Please wait. Come to paragraph E at page 24.
But I made it that your applicant states that immediately after the death of her father for getting appointment on compassionate ground, your applicant had submitted application in proper forma, proper pro forma before the respondent concerned on 21st of September 2010.
That is admitted position.
Next.
Yes.
Be it noted here that your applicant and other members of the family had also made several representations before the concerned respondents for compassionate appointment under the died in hand category in favor of the applicant.
Yes.
The Xerox copies.
Yes.
Now, but the difficulty was that the office of the block development, they refused to accept my application on
That
the
you have not said anything.
not
In a reply, you cannot make out a new case.
no. But your lordship, kindly give me 1 minute time.
Yes.
But when my lord is hearing me patiently, but
Yes,
kindly
but
gives me
the patience is not to be taken to be in this way that casually you will make any submission.
no, not casual, but I am
This
backed
is
by the
this is the statement verified by your client before the tribunal
true.
in so many words in the original application, that she made an application for the first time and she says immediately. This is immediate. That immediately after my father's death, I made an application on 21/9/2010. And then be it noted that we had also filed some representations. She does not say that I was not issued any receipt or it was not accepted. Nothing is said.
But your lordship,
These are not open to submission. These are issues of fact.
True.
And you cannot make a submission which is not pleaded on an issue of fact.
but I request your lordship, my lord,
Yes.
to consider the plight of a person.
Sorry. You cannot arouse the sympathy of the court.
No, not sympathy.
We have to go by the facts as they are. And you don't get, then somebody else who is requiring compassionate appointment will get in your place.
Absolutely.
Because the quota for compassion is reserved.
Absolutely.
It is not open-ended. So
But
it is
I request
whether the more deserving compassionate appointment beneficiary should get or the less deserving. That is the issue before us.
but
It
only
is
one
unfortunate for you. It is unfortunate for the other who will lose, who may have come on time and you have come after 2 years. So these are issues which weigh in mind of the court. It's not that we don't realize that you are undergoing penury. Of course, there is a loss. All these things we realize. But that there are two grounds for rejection. In the first ground itself, you are disentitled.
Married
2 years. 2 years.
2 years.
Yes.
Yeah, my lord, when I opened my case, your lordship said that no, that is not the issue. But still,
No, we didn't know that it was 2 years. We thought maybe a month or so.
no.
2 years is shocking. 2 years is shocking. Where a limit is of 6 months, 2 years is shocking. 1, 2, 3 months, of course, we could have understood whether a hyper-technical approach is to be taken or not.
Kindly, but I request your lordship, my lord, to show my lord, some mercy, some leniency, my lord, in
We
this
said
matter.
we are not here for dispensing mercy. Unfortunately, we are not here for this.
My lord, your lordship, kindly
Yes,
consider.
take down.
My lord, your lordship, kindly, my lord, may I? Only.
Yes. Enough. 2 years is too much. Rejection of your claim.
But on the strength of this notification, my case has been dismissed.
No, sir. On the strength of 2013 notification, it has
But
been dismissed.
2013 has been modified in 2016 and
16, and that modification will not apply to you because it was 2014. By now we have seen in many cases. It's not the first time. Therefore, we are saying Third Land Council for the Therefore, we also allow you and we encourage you, but
I'm so grateful to you.
Item number 11.
Lord, I am for the petition. I'm for the respondent in this matter of private respondent. Lord, my entire, Lord, post-retirement service benefit has been withheld by my employer only on the ground that a private criminal case is pending. That is the only issue. And Lord, the tribunal has misinterpreted the regulation 10 of the DCRB and says that in case Lord, the allegation is 420 and 406. The only allegation is that Lord, the 3 persons, including the present rate petitioner, they collected money from the villagers in the lieu of giving them appointment in the government job. And that is why the criminal case was initiated against him. I was working as Lord, the presently Lord, the assistant health assistant.
Health inspector.
Health
Health
inspector.
inspector.
My lord.
it is a district cadre or it is a
Health inspector in a district cadre.
district cadre.
And each district has a health inspector.
Lord, the only kindly consider
Within the CMOH.
CMH.
Of a particular district. It is called health district. There are 2 districts, police district, health district.
The health district may overlap over some other police districts also.
Yeah,
They are not conforming to the police district.
normally health district. Can you see, for example, for Birbhum. Birbhum is a district, 2 subdivisions, Rampurat, Bolpur, and Shiuri. Shiuri is a health district, but Shiuri, part of it, Shiuri has been cut off from Rampurat or something other, because depends upon the ability of the hospitals in the local area.
The health inspector, he inspects the quality and things like
Local hospitals, primary hospitals are there, other
primary health centers.
primary health center or other health centers are there. And medicine has to be purchased on the basis of his requisition, and sample has to be forwarded to the government.
So only pension must have been withheld.
But only the pension, gratuity, provident fund, it's all the Lord, the admissible service benefit has been withheld.
Gratuity, provident fund also.
Everything, Lord.
That is another rules.
We have decided recently in one case.
Judgment possibly has not been rule 14.
Ah.
No. My lord heard Mr. Chatterjee and myself. Possibly judgment has not been. But,
Anyway,
Lord,
that case there was a agreement with the builder
builder,
taking a loan.
loan.
Lord, the regulation 10 of the DCRB, according to me, subject to correction of your sanction of your lordship, that is applicable. Lord, that is applicable in case that causes any pecuniary loss to my employer. Lord, this criminal case which is pending, that does not cause any pecuniary loss to my employer.
What does the provision say? Criminal case involving moral turpitude.
Moral turpitude. Even Lord, the rules, my lord knows the rule 14. In case of the moral turpitude, Lord, there is a provision for giving the provisional pension.
Therefore, we ask you, everything has been withheld or some?
Everything, Lord. Everything, Lord.
And my lord friend, what is submitting that until unless pecuniary loss is there cannot be continuation of the dispute proceedings, even after retirement. That was a decision taken by our division bench. The state government preferred an appeal before the Supreme Court. The Supreme Court on 15th of October 2014 held that not only for pecuniary, any misconduct.
Correct. So
Yeah,
therefore,
paragraph 3 to 6.
misconduct or loss caused will arise only when it is in relation to his work.
Yes.
If it is for some other transaction, then that whether that is to apply or the moral turpitude thing has to apply.
And that is reported in 2015 to SSC page.
That is not his case. That's not his case. That is not his case. He is saying it is nothing to do with his employment. Not only that, there is no loss caused. He is saying it is nothing to do with his employment.
Can you see the language?
Who are you?
I am working on the basis of my complaint, the FIR was initiated.
Sorry, you are not to be heard. Yes. You have nothing to do with grant of his pensionary benefits. You proceed against him, you take up your case in the criminal trial. Sorry, you may be, you are not
Can you see
required.
14?
We'll record that we don't want to hear you. You are the complainant. Why should you be heard here? What the state is to be doing? You have no business to say anything in what the. You are here, just give your appearance. We don't think you are a necessary party. You have nothing to do with this claim. This will not affect the criminal trial. You pursue your criminal trial. Why are you here? Sorry. Yes.
Rule 14.
Why did you make him a party? How is he a necessary party?
But that was, Lord, I understood what is falling from your lordship, but when the matter was adjudicated by the tribunal, the Lord, it was observed, it was Lord,
Not a necessary
Lord,
party.
I
Neither
understood.
necessary
I
nor
got it.
proper.
Yes, Lord. Yes, Lord. 14 deduction, sir.
Rule 14.
Lord, may I be hand over the-
Yes.
Rule 14. He said the rules.
Yes, we have it. Yes, Rule 14. Rule 14 will apply.
Until criminal case is disposed of.
But if Rule 14 applies, then nothing more than the 2/3 can be withheld. There is judgment of His Lordship Justice Dipankar Datta we have considered in that case. Pension here does not include gratuity. You had argued that pension includes gratuity. We have, I remember we had dictated the order in court.
No, order as hearing concluded, waiting for that.
Oh.
The Chatterjee, even after argument, wanted.
In this case, you had filed a opposition before the tribunal.
No opposition. No, Lord.
No opposition.
No opposition.
So it has what disposed of on the first date.
But it was decided.
Order number 2. That is most probably first day.
Second day, first day's admission, second day, Lord, the matter disposed of.
Rule 10 will not apply. How Rule 10 will? Where is the complaint?
Complaint missed page Lord 24. Page running page 24. Lord.
FIR page 29.
How can we consider, sir?
30.
Lord, may I
Page 30 is
translate this, Lord?
Please. Come in the next week. The short issue, yes, the short issue. The short issue. We may direct. You are not most unnecessary party to this proceeding. Not at all. You want to file whatever we are not stopping you.
না 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 ওই একটা ট্রান্সলেশন করে দিতে হবে।
Item number 12.
You only have to see whether
এত বড় ব্রিজ কেন রে? এত বড় ব্রিজ কেন?
না না সাপ্লিমেন্টারি কোর্টের পারমিশন ছাড়া দেওয়া যাবে না। My lord, I am assailing an order dated January 29th, my lord, 2025, passed by the tribunal, my lord. The petitioner before your lordships is a, my lord, a police officer in the rank of a sub-inspector of police. He joined the service as a constable in 2006, my lord. He appeared in the departmental promotional examination and he was, my lord, appointed as a sub-inspector of police, my lord, after promotion.
So from constable, he became,
He appeared for the departmental promotional examination. So he, my lord, he got promoted as a sub-inspector of police.
constable to sub-inspector.
No. Promotion is sub-inspector to assistant sub-inspector, head constable to assistant sub-inspector, then sub-inspector.
Correct.
There was a departmental examination, my lord. I appeared in that.
So he had
Prior to
already,
that, he was, my lord, posted as a constable in the CID, Criminal Investigation Department.
so after constable, head constable, then sub-inspector, assistant sub-inspector, then sub-inspector.
But sub-inspector all are direct recruitment.
Oh. So there are two modes of recruitment, open and departmental.
Yes, sir.
So he participated in through the departmental challenge. There is a quota fixed,
There is a quota fixed, my lord.
20.
My lord, that percentage of the quota, my lord, I do not know
Anyway,
as of
may
now,
not be
but I
relevant.
will
May not be relevant. Yes. So that till that there is no dispute.
No dispute. So, my lord, continuing service is as presently 19 years. My lord, my lord, within the-
Continuing, when you say you include the constable
yes,
service.
that was approved, my lord. That was approved. My annexure P1 is the approval letter. My lord, within a span of 2 years, my lord, I was transferred on 9 occasions, 9 times. And my lord, the transfer order dated 24th of August 2023 was challenged before the tribunal in 2023. My lord, that OA remained pending. While the OA was pending, my lord, I was thereafter transferred again twice. So, my lord, I challenged the transfer order of October 2024 in a my lord, subsequent OA. My lord, reply rejoinder was called for in the earlier original application. But my lord, these two original applications came to be heard by the tribunal on the same date. My lord, the reply rejoinder, my lord, the earlier OA was dismissed being infructuous, and the reply and rejoinder in the earlier OA was used, my lord, for passing the order in the subsequent OA. No fresh reply rejoinder was, my lord, called for the subsequent original application that we had filed. This is one aspect of the matter. And then, my lord, as of now, I have been, my lord, transferred
Again,
my lord, on the date of filing of this writ application. Again, I have been transferred. So this is, my lord, the 12th transfer within a span of 3.5 years, 3.5 years. Lord, the points that we had, my lord, highlighted before the tribunal that, my lord, the transfer order, at least the last few of the transfer orders, my lord, are punitive in nature. And it was, my lord, at the instance of, my lord, officers against whom, my lord, I had complained, or, my lord, I had made some, my lord, I could not obey the orders that I was given, my lord, because it was not coming within the purview of my duty. Lordship, kindly takes page 33 of my application. I have indicated the, my lord, the number of transfers till the date of, my lord, filing of the subsequent original application. And if your lordship may kindly consider the impugned order, my lord, the observation of the learned tribunal was based on the, my lord, reply submitted by the state in the earlier original application.
Page.
My lord, 33. My lord, this is from 2021 to 2022, the number of transfers, my lord, I have been issued. Till 2024, I'm sorry. My lord, in the year 2022, my lord, a transfer policy, my lord, have been formulated by the department, police department. That is, my lord, at page number, my lord,
So there is no opposition.
there is no opposition. And I did not, my lord, get an opportunity to submit my reply. The earlier original application, if your lordships may kindly consider, my lord, was, my lord, of the transfer order issued in 2020.
What report has been filed by the Superintendent of Police?
My lord, this is the reply, my lord.
No, it says the Superintendent of Police in his report filed before this tribunal. Which report?
Lord, I have submitted the reply that was submitted on behalf of the, my lord, the state respondent.
No, it says report.
Report, it says, my lord. Report.
Where is that report? Mr. Mukherjee, there is any report?
আমাদের কি রিপোর্টের কপি দিয়েছিল চাইতে গেলে রিপোর্টের কপি এই স্পিড একটা সাইড রিপোর্ট কোথায়
Because it is based on this
My lord,
report
it is based on this.
that the tribunal has arrived at a conclusion. So whether there is any report or not, whether you have said that it is a wrong error of record, there is no report, or there is a report, we don't know. Is there any report?
I don't have any.
You find out. Let him find out. You will also assert
I will also.
the order of the tribunal. Please say that there is no report.
Lord, may I pray for one indulgence, my lord? My lord, he has been transferred, my lord, to Baruipur. Thereafter, my lord, on the date of filing of this application, he has been against transfer. My lord, let him remain at Baruipur, my lord, till pendency.
He has
of-
again been transferred after filing the writ petition.
Yes, on the date of filing of the writ petition. My lord, I have prepared a supplementary affidavit to that effect. My lord, only prayer is, my lord, let him remain in Baruipur till, my lord, pending this application.
What is the date of his posting at Baruipur?
His date of posting at Baruipur, my lord, was
No, next.
Is it on the record?
Baruipur on the record, my lord, because Baruipur was issued when, my lord, the original application, the second application was filed.
No, you said after filing the writ petition also.
On the date of filing of the writ petition, he was again transferred from this Baruipur to.
Is that order on record?
No, my lord, that is in the supplementary affidavit.
Without, you are filing it.
My lord, if liberty is given, my lord,
You file it.
I am filing it. My lord,
The
giving a copy to my
supplementary
learned-
affidavit being filed on Item number 22.
Order প্রথমটা
দেরি করে জায়গা নেই হেরে যায় অলরেডি পাস হয়ে আছে একটা অর্ডার লিখে নিয়েছি 12 হ্যাঁ এটা পেয়েছি 99 এটা পেয়েছি ডব্লিউপিসি 99 24 এটা তো হয়েছে না তিনটে ম্যাটার বিকাশ দাস ছিল তাই হবে অলরেডি তিনটে হয়ে গেছে আমি এটাও দেখলাম 99টা হয়ে গেছে এটা জাস্ট সিমিলার তাই তো যেরকম practice করেছে তুলতে তুলতে সময় লাগে 11 মাসে হয়েছিল
So who is appearing in 22, serial number 22?
Yes, I'm for the
Both sides are represented. So all have to be same order as we pass.
Only may I give one adjustment?
Yes.
Maybe not to stipulate time limit because earlier judgments have not been implemented.
Not implemented.
They have not been reinstated.
But what is the date of the earlier judge?
No, no.
Perhaps retired. Retired.
Yeah.
No, I was in the impression that he has retired, but he has not retired.
They are quite young.
In those cases, we have not fixed any time.
No, that's why my lord. November the orders were passed by till date.
We can add it.
WPCT 98 of 2024. Who is representing the petition?
We are appearing
98 of 2024.
in all matters.
All the matters. So Rajkumar Ranjan,
Yes.
has he superannuated?
No. He's working. He's a young man.
How can we know?
No. I am saying he's a young man.
You should not be surprised that we don't know. You
No,
should
no.
presume that we don't
Yes.
know.
WPCT 98 of 2024. I'm going through the last two paragraphs only, not the entire order. We are not in agreement with such submission advanced by the respondent for the simple reason that the respondents themselves, while passing the consequential order of reinstatement in terms of the order passed in writ proceedings, have maintained continuity with the earlier order of removal by incorporating suspension with effect from the order of removal. The respondents are thus stopped from contending that while granting consequential benefits, the period covered by the earlier removal cannot be reopened. We therefore do not accept the submission of the Learned Counsel for the Union of India in this regard. It is by now clear that in respect of both the periods arising out of order of removal dated 3rd November 2018 or based on the charge memo dated 11th January 2022, the order of punishment is
Item number 13.
May I please, Your Worship? Before going to crux of the matter, my lord. Yes, ma'am.
And charge memo in 24.
Yes, ma'am. My lord, stale charges. When charge, my lord, the employer, my lord, they started vigilance 2022. They issued memo of charge sheet to the petitioner 2024 when the date of superannuation of the petitioner is 31st March 2024.
And what is the date of the charge memo?
My lord. 27th August 2024. My lord, that is
24.
Yes, ma'am. চার্জ মেমো ডেটটা পেজটা বলো তো আমি এতে দাগ দিয়েছি হ্যাঁ my lord
But it
kindly
is pending before the tribunal, then why have you come here?
my lord kindly see the order.
Which
This
order?
matter, my lord, taken up by the tribunal thrice. First on 22nd January 2020. No, my lord, first in 18 November 2024.
Yes. So in every case, if the tribunal takes 3-4 dates, then the High Court should take up the matter.
Only one thing, my lord. This is not a case, my lord. We are asking for only expeditious hearing. You are asking more. Considering his, my lord, date of superannuation, now, my lord, what is the practice of the state government? The practice of the state government is before, prior to the six month of date of superannuation.
We are not on the merits. We are saying when it is pending, why the High Court should take it up?
No, but kindly see the order, my lord.
It has fixed it for hearing. It
Here-
will take up.
My lord, kindly see the order. My lord, some.
Which order? There are 3 orders. So which order you are referring to?
My lord, yes.
Oh, yes, please.
Kindly close your lordship brief. My lord is well aware of the circumstances. If there is a stay charge,
We are before entering the merits. You have to cross the hurdle. Why the High Court should take it up? We at the outset, we asked the query that 2007 charges in 24. Bani Singh and all these judgments, you will be relying upon that. We have understood whether it is stale, whether it is not. But why the High Court when it is still pending there?
because the landed tribunal thought it fit not to interfere at the stage. That's the grievance before my client, before my lord. If on the face of it, my lord knows the money is followed by some said it will not stand for a single minute scrutiny. That will go.
But that is the final order that cannot be passed by way of an interim relief.
What is my prejudice? Can you see? At the verge of my retirement, a proceeding initiated.
Correct. That we have seen. That we have seen.
If
That
that
we
is
have
so,
seen.
then
Yes.
my lord, my prejudice is apparent.
To you, it is apparent the tribunal has to decide. To you, it is apparent.
What he has said, tribunal said.
Yes, let's see. Which order? 17-2.
2017. 18 November 2024. Sir, impugned order.
2024.
Kindly come to the order impugned. That is at page November 2020. May I read it, Your Lord? The matter is taken up by the single bench, pursuant to the order contained in notification. Let affidavit is submitted by keep by the record, sir. The prayer in this application is for a direction to the responding authorities to exercise the charges and enter department of proceeding initiated against the applicant. At the London Council, the matter is admitted.
Admission in November 2024.
Like my lord, the order for your admission is made, but thereafter nothing. This is all.
Next matter, next order. By Shankar.
All right, but
Next order is 22nd. That is section upon hearing with based on adjournment. Adjournment. Please continue. I will not get. Now I will kindly see what is my prejudice. Kindly come to.
opposition has been filed before the tribunal.
May I indicate one thing? What the
We
opposition?
don't want to go into the merits. This is not the time for going into the merits.
Why I am saying?
Yes.
Yes. Matter where the allegation is the charges are still.
That is on the merits.
Why I am saying?
Yes.
Give me minister. If like it is like order 7 rule 11 of the court, you have to go by the plaintiff itself for rejection.
The Administrative Tribunals Act says civil procedure court shall not apply.
Not saying proposition
Yes.
applies.
Yes.
When we are challenging a state charge, that means the charge sheet will speak out. You cannot develop.
Correct.
So, my lord, still from my lord, the Mohinder Singh Gill's case, it said by document you cannot develop.
Where is the question of developing?
So,
They have yet.
I am asking myself, why is the affidavit?
We don't know. They may proceed without affidavit.
I am submitting, my lord. Your lordship.
We are not here to go into the merits at this stage. L. Chandra Kumar judgment is clear. The tribunal has to be the court of first instance.
If the first instance
And therefore,
nothing of his exercising jurisdiction.
there is no lack of jurisdiction. 3 adjournments are there.
Once come to the charge.
We are not going to go into the merits. This is not the time to go into the merits. Please try to understand.
To my humble submission, this is the stage in a stage charge.
We will consider that submission.
Had it been a case, my lord, a proceeding initiated, I was punished. I cannot say that the authority will not have a file to affidavit. But in a case where, my lord,
what is the next date? What is the next date fixed? What is the next
date? I am going to retire, my lord. Kindly see
31st March.
Kindly see, my lord, the
195.
Kindly come to 194. Kindly come to 194. What should I do?
194.
94. See my predicament.
What is 190?
Can you see that? They are not supplying due to the pendency of this. So after 31st March, I will be retained in service for the purpose of initiation of proceeding.
Obviously, you have to. That is the procedure. There's nothing new.
So I am submitting, my lord, when there is no proceeding.
So when you are continued for the purposes of proceeding, you will get your subsistence allowance.
I will not.
How you will not get?
Subsistence allowance.
Under which provision?
There is no provision, I see.
So once you are continued in service for the purpose of proceeding.
That is better than me. Only for the purpose of continuation of proceeding, not for any other purpose. But the other purpose, my relationship between the employer and employee ceases. But I will not get any amount. I cannot survive. My promotion is due.
Promotion after retirement.
No, it has not been done. So
all those things will be considered only when the tribunal decides, not prior thereto.
Let me cite this judgment for
Yes, you may.
Where it says that it cannot continue.
No, we are on the issue. That comes later. When the matter is pending before the tribunal, why the High Court should. First, you have to cross that. Then everything we will see.
My lord, I am giving the instance.
Yes.
The code, my lord, dear my lord, applies section 115 of the code. If the
That will not apply. We are getting jurisdiction only because of judgment of L. Chandra Kumar.
natural justice is the speaker of all proceedings.
Correct.
Your court is on the court, whatever. Where it says if the lower court failed to exercise its jurisdiction or acted in excess of its jurisdiction, the higher forum can exercise his power in a given case. What is the case here? My submission before the tribunal was that kindly see, this is the charge sheet. This charge sheet is of 2007, you are issuing it on 2004. This fact cannot be denied because charge sheet is there. If charge sheet says a incident of 2007 has now been proceeded with against, then it is still charge. Apart from that, my lord, your lordship's court judgment says if after the incident I have been given promotion, that will evaporate. Am I clear to my lord? Then I submit, my lord, there is no affidavit needed. What affidavit will do?
So the moment you filed the application, tribunal should have allowed the.
Allow what is this? It should say that no, I find these charges are not stale. So you require a proceeding to be received. I am not on that.
All right.
I am saying where it does not require any affidavit to be filed because court has to consider only and only the charge sheet. If charge sheet fell out, that charges of 2007 got to be expended down 2014-24. Then these are obviously coming under the parameter of money others. In that event, court is nothing else to examine. I repeat, court has nothing else to examine, only the charge sheet and charge sheet only. That I approach before the tribunal that kindly look to the charge sheet and decide whether the proceeding can be continued or not. That jurisdiction the tribunal has got to decide. I want to carry on. That's why you want to show to your lordship the charge sheet. Kindly come to the charge sheet.
We are yet to come across any such judgment that because an applicant is sanguine that his case is to be allowed, therefore no opportunity should be given to the respondent. Without giving him them opportunity, how the tribunal can proceed?
Not make myself clear. Again, I kindly allow me to repeat.
No, we have understood what you are saying. There is nothing to look into beyond the charge sheet. Therefore, they should not be asked to file affidavit also. Can we conceive of such a circumstance that they will not be allowed to file affidavit also?
While dealing with my lord, the order 7 rule 11 applications.
The problem is you are applying order 7 rule 11. Here the tribunal, as per the Administrative Tribunals Act, is to be guided by the principles of natural justice. So therefore, without giving them opportunity, how the tribunal can decide? Has to give. If we hold that, that will be contrary to the procedure in the Tribunals Act. They have to give a reply. They have to be given an opportunity. It may be an open and shut case, as you are saying. That we have understood.
That's why you want to show to the charge.
But this is not the time for us to look into it. We are not going to assume the tribunal's jurisdiction.
My lord, the case there, my lord, before my retirement, a fake charge sheet to be initiated against me, and I will not get the protection of the court.
We don't know. That is for the tribunal. That is for the tribunal to see, and once the tribunal has decided, then it will come.
Can you see the order? I've shown to you see the order.
Therefore,
I say I approach the tribunal. Kindly look to the charge sheet.
Yes.
See, it is stale on the face of it.
So you are saying there is a prima facie case, therefore there should be.
That's my case. On the face of it is nothing to be looked into. Can you be satisfied? Be satisfied, not your conscience. The charge sheet I once allow me to place.
Yes, place it.
At least to that extent.
No, place it.
Kindly come to page 34.
Yes.
This is an order 8th May 2007. I was promoted. Kindly take a note of it.
Yes.
I was promoted in 2007. And now kindly come to the charge sheet, page 48. Page 40. Okay, so Photologically got it, well. Undersigned proposed to hold an inquiry under Rule 10 against Samuel Kumar Das, as such, the substance of imputation misconduct suggests. Your Lordship will come along. This is the charge sheet issued. A statement of the imputation of misconduct that I have to place before my. Now kindly turn over and come to page 55, the articles of charges. I have shown to your Lordship the date. Date is 27th August 2024, the date of charge sheet. Has Manoj kindly got it?
Yes, we have got it.
Then kindly come to page 55. Samuel Kumar Das, while functioning as educator during the period from 6 June 2007 to 6 May 2013. This is the alleged period of so-called misconduct.
Yes.
So this is their allegation. I take it to be true.
Yes.
Is it not coming under the manner vanishing? Can it now be proceeded with against in the eve of my retirement?
Yes.
This is the imputation of misconduct, and that too 6,30,714. Where, my lord, this every time I give my statement, my lord knows in the government service I have to give every time. And there was a complaint against me in 2012, inquired. No result is not forthcoming. Even on that score also, my charge against me is still on the face of it.
We are therefore we are restraining from making any comments on the charge at this stage because it may not be proper at this stage.
Why not?
Because you see article number 3.
Article 3.
Yes.
Yes.
It is allegation of suppression of facts in the year 2020. Just read article 3.
Yes.
Yes. Is that a stale?
Functioning as such and such, the people executed has the period of 6 June 2007 to 2020 submitted his annual declaration of assets and such put on 2011 to 2018.
Having suppression. Now this charge of 2020, is it a stale?
I still say this is my lord.
We are not in correctness. You said on the bare reading, on the face of it. Now therefore, this 2020 charge will be stale. Suppression in 2020. This is not correct.
Read it.
Yes.
2020. This is not on 2018.
No, this is for the period 1/1/11 to 1/11/11/2018. Yes. And this is but during the period 2007 to 2020, you submitted annual declaration of assets. So these assets declared in 2020 are also alleged to be a charge that it is suffering from suppression of certain material.
Correction, my lord, if you lordship read the entire.
Therefore, we are saying that we should not go into this.
If you lordship see
whether it is stale or not, then we will have to say.
Who will decide that?
That is where you have gone. They will decide.
Then, my lord, there is no judicial member.
We don't know.
Yes, ma'am.
You have invoked the tribunal's jurisdiction. You have invoked the tribunal's jurisdiction.
Who will decide that?
It is being taken up.
There is the judgment of the lordship's court.
It is being taken up. You have both agreed to appear before the single bench. It has been taken up. It has been admitted for hearing. There is no objection by you that I will not appear there.
No objection will not create jurisdiction. That is well said.
Very well. We don't want to go into this issue. This charge is, we have seen, therefore, at the outset we were observing. We told her, we gave the date when it was called. That 2007 you are referring to. She said, yes. We have seen the third article charge also. So 2020, whether we are not into the merits of the charge.
Lordship did not. On the plain reading.
On the plain reading, read it.
From 6 June 2007 to 18 November 2020.
20.
Submitted his annual declaration of assets.
Yes, by resorting to suppression. Yes.
Statements as they stood on 1st January 2011 to 18.
Having suppression of material particulars. So 18 up to 18, the assets which you had acquired, that has been suppressed in 2020 annual declaration of assets. This may be correct, this may be incorrect. But then how it can be a stale charge?
2018.
Even if it is 18, it will not be stale.
6 years.
Maybe 6 years, every charge will not become stale. On the 7, it would have been shocking. Therefore, we ask that you are harping. It is. We had asked that the basic is 2007, but it is not the only charge. Therefore, they are required to have an opportunity to say what they are saying, and the tribunal will decide. It has fixed a date already.
And that
File an opposition
single bench
immediately.
cannot decide that.
You file an op. We don't know in May whether it will be single, whether it will be division. Date has been fixed. In May it has been fixed, sir. What will be the position then? We don't know. Whether that it will still be a single or double, we don't know. Or no member, who knows? No, no. Why are you not filing your opposition? Why are you delaying the matter? We have on record 3 dates over a span of 1 year. 3 dates over a span of 1 year. What instruction? How you will take endless time to file an opposition? You file it within 2 weeks. You file the opposition within 2 weeks. On the next date, the
So, my lord, I will read that.
what can be done, sir?
At least, my lord, do something so my pencil papers are sent.
There is a prayer.
Not in the face of the charges pending against you. It cannot be done. Every relief that you pray for has to be considered in accordance with the law. How can we stop when the charge is already issued? Then how it can be stopped?
No proceeding. In the proceeding also not continuing.
So therefore, we are no. They have said that continuing. It is continuing.
Not proceeding in fact, in effect. I don't know when it will conclude.
No, see what it says. You were there.
Says, but in effect,
the tribunal does not find any inordinate delay in concluding that.
So it will proceed. Not proceeding. In either way, my lord, I am trapped totally.
That is unfortunate circumstance. What can be done? At best, we can say that on the next day it will be considered. May it has been fixed. Let them file the opposition within 2 weeks. You file your reply. On the next day, it will be considered.
My lord, may I request on the tribunal decide my precise question, which I now canvassing before my lord. That has to be done.
That has to be. That has to be.
What is said? What is the reasoning here? That there is no delay in proceeding with the departmental proceeding. Set aside the
No. Do you have a specific instruction that opposition has not been filed before the tribunal?
Not filed.
Please.
Next date is May.
May 8th.
Of whether they have filed opposition. No.
Now, once again, what is the finds? The charge sheet dated 27th August 2024 and the ended departmental proceeding is proceeding. So there is no delay of disposal of the departmental proceedings.
That's
it has not.
That is why we are asking. That is why we are asking whether they filed opposition. If they have not, how this finding has been recorded, we don't. Very well. Don't worry. We'll take it. It's Third Land Council for.
to some extent struck down. I appeared on that matter for the bar. My submission was accepted that this tribunal constituted is a total farce. Total farce. It is better, yes. Three judges bench. Justice Bhaskar Bhattacharya, Justice Procedural Mandal, Justice Tapal Dutt. What my lord is getting any effective for the litigant? Only thing, my lord cannot say in sitting here, I can say. Only thing it is for the post-retirement benefit of your lordships. Nothing else.
Call the next. Disposed of. Matter stands disposed. Yes, obviously. Steel, STAL.
Number 14.
Mr. Animal Mitra is appearing on behalf of the petitioner, my lord. We could write that, my lord.
Yes, we thought he was here today. He said he will be here today. Oh, I thought he was going to be here today. Therefore, I said, you wait, let it be called. Oh, very well. How much time? When he is back?
It date may be fixed, my lord, after 4th April, my lord.
Any opposition is to be filed. Oh, it was, we were hearing the matter. Yes. As played on behalf of the petition.
Number 15.
My lord, I'm already take time for on this matter. I'm apologized for that. And today, learned advocate not appeared, my lord.
Where is the affidavit of service?
It's already done, my lord. But
Where is the
but learned advocate not appeared today. I'm praying for not today, my lord.
Not today.
Sixteen.
Respondent just now received the fresh copy. Praying adjourn.
Fresh copy.
Yes.
No, actually, I was not in the matter. My learned junior apprised me that the paginations were not tallying and your lordship desired that a fresh copy should be served.
Has been given.
And now, on persuasion, the officers have been able to trace out the file, and my learned junior has served a copy. So let it be on Friday.
So do we have a file which is in coherence with the?
Yes. Now we have a file.
So are you filing it?
It has been checked. I was not in the matter. My learned junior has checked up.
No. What we want to know is that the revised paging is in accordance with our file, or that has to be now given to us also.
Yes.
I am told your lordship's file has 59 pages.
Yes.
Lordship, it is in coherence.
Now it is coherent with the file. So we don't need to take any further file copy of the brief. We can proceed on this basis.
And adjourn for 2 weeks.
2 weeks. Why? It's the same thing. They have just cured the paging.
Find the adjournment.
Huh? A complete brief. The date.
Number 17.
But I appear for the respondent.
Who is for the petitioner?
So Kallal Basu appeared, this is that matter where the transfer order was issued at Jammu and Kashmir Court adjudication. And your lordships have been pleased to hear on the issue whether the entire period shall be regularized during the transfer issue. I don't know why he is not.
My senior is on his legs. He's coming in a short while.
Then we'll do next week. I have a
Next week.
Next week. I'm heavily engaged in this.
Yes.
Your lordship.
1 week is seconded. 1 week. Seconded. Why 1 week? 1 week. 27th. 27th.
Short pass over, Mr. Bush is on his legs, short pass over.
He will come.
I am for the respondent in this matter. But I am for the respondent in this matter, I think.
Yes, we have heard.
I am for the respondent.
There are points decided by other administrative tribunals, went up to the higher courts, compared with by the central government.
Last
The same issue.
last occasion, my lord, lordship was directed to satisfy the lordship, my lord, whether why it is not complied with pertaining to the judgment of the SK Murthy. But I have obtained, my lord, few judgments regarding where my lord, kindly seize this 2015-7 SCC Supreme Court, my lord. Kindly see my paragraph number 32. Page paragraph number 32. Page number paragraph 32 page number বলে দিচ্ছি আপনাকে প্রিন্টেড রয়েছে kindly seize, my lord. Generally, the admission of the fact made by the council as binding upon their principal as long as they are unequivocal. Where, however, the doubt exists as the purported admission, the court should be ready to accept such admission until and unless the council of the advocates is authorized by the principal to make such admission Furthermore, a client is not bound by the statement of the admission which he or his lawyer was not authorized to make. A lawyer generally has no implied or apparent authority to make an admission or statement which would directly surrender or conclude the substantial legal right of the client unless such an admission or statement is clearly a proper steps in accomplish the proper for which the lawyer was employed. We hesitate and add neither the client nor the court is bound by the lawyer's statement or admission as to the matter of law or legal conclusion. Thus, according to generally accepted notions of professional responsibility, lawyers should follow the client's instruction rather than substitute their judgment for that the client. We may add that in some cases, lawyer can make the decision without consulting of their client, while in others, the decision is reserved for the client. It is often said that the lawyer can make decision as to the tactic without consulting the client, while the client has a right to make decision that can affect his right. My lord, on last occasion, my lord, lordship has directed why you have admitted in the as in way application that one second. Why it has been admitted in the CAT that we are granting others and not this the petitioners here in regarding this, I have submitted this judgment that the averment of the advocate is not, my lord, not in per se with the averment of the client, my lord.
So what is the remedy in such a circumstance? If a wrong concession is recorded, then what is the remedy?
My lord, remedy in that sense, my lord, first of all, my lord, the present SK Murthy judgment is not applied here, my lord.
Again, we are asking you. You don't deny that a concession was recorded. You say it was without taking any instruction. So what is the remedy in such a circumstance?
Actually, my lord, matter is
because we have recorded an order that you may suffer consequences. Therefore, we are asking you. We are giving you all the opportunity because we have already expressed in our earlier order that filing of such a writ petition may entail some consequences on the Union of India. Therefore, we are giving you this opportunity. If the concession has been recorded wrongly for any reason, what is the remedy?
remedy, my lord, at that point of time, if, my lord, any consent has been recorded in any manner, my lord, that has been opportunity is given to the, my lord, the department so that it is clarified, my lord. But thereafter, my lord, kindly sees, my lord, 1998 6 SCC 538. Okay. Kindly sees, my lord, the paragraph number 23.
On which point?
Regarding this point, my lord.
Why you are giving multiple judgments? This judgment is enough. You need not give us 10 judgments on one point. This is also Supreme Court.
Yes, Supreme Court.
You have made that point. What else point?
My lord, rest is if, my lord, permit, my lord, Mr. Ghosh is came and submit before the appraisal.
Rest, no submission. We had asked only to submit on this. Whether you can take a different stand being a state within the meaning of Article 12, you can take a different stand with respect to two different persons claiming the same relief under the same provision. That is the first aspect. The second aspect is whether you can approach this court after giving a concession before the trial. These are the two issues. So on one you have said, now we are asking you again, if the concession was wrongly recorded, what is the remedy?
Opportunity.
What opportunity? What do you mean opportunity? We are asking you what is the remedy. You are saying opportunity. What opportunity? What do you mean by opportunity? We are unable to understand.
My lord, kindly comes, my lord, the ordering part, my lord, in the
We are not going into the merits. Both these issues were to be canvassed by you.
kindly in this regard, my lord, kindly make it short password because my lord, in this regard may apprise by the Mr. Ghosh to for the planet code, my lord.
Yes, we should be. Okay. Right? Every day we transfer will be separate process. Some that justice gives us separate profit. All that is connected from cost. Show me that judgment. Where is he? We are waiting for him.
And on his legs, man, another. But kindly give my lord half an hour time so that we can apply for
Him to be here tomorrow, not today. Send this file.
Item number 19.
This letter I am led by Mr. Dipendra Nayan Ray, my lord. On earlier occasion, my lord, order dated 28 January 2025, directed to five written instruction, my lord. Our written instruction, my lord. The department, my lord. About rule 205, my lord. But there is no such rule, my lord. The rule is 1502 of IR volume. Overtime allowance is an allowance paid to railway servant for actual time work in excess of the hours of employment prescribed by any law approved. The duty of hours of ACCA and ACCM is 104 hours in 14 days roster since classified as continuous category in terms of railway board letter, such as including days of rest for computations of duty hours of AC coach attendance, and in charge railway board has issued instruction where it is stipulated the staff additional time preparatory to organize originating station and 1 hour as complementary after the arrival as destination station in each trip, 4 hours as duty of the purpose of overtime allowance. During the half period, another set of maintenance staff are liable to taking over charge of the AC coaches from the ACCAS and ACCMS, so they are not required to perform any official duty and remain idle. Therefore, this my lord. And my lord, also my lord, principal bench judgment, my lord.
We remember everything from January.
Kindly see the my lord principal bench judgment, my lord.
What judgment? What is the issue? Tell us what the tribunal has done.
Cannot be.
Lord, may I submit for the respondent?
Yes.
Lord, this matter, the issue has been decided by the Central Administrative Bombay Bench regarding the overtime allowance pertinent issue. They have asserted the matter before the Bombay High Court. The Bombay High Court affirmed the order passed by the Central Administrative Bombay Bench. And thereafter, they have again approached before the Honorable Supreme Court. The Supreme Court dismissed the matter on merit. Now they have implemented the said order in respect of the employee working in the Western Railway. But in respect of the Southeastern Railway, they are not giving the same benefit. Tribunal has recorded the
what benefit?
The overtime allowance because they are the
coach attendants.
Air condition coach attendant. Yes, Malad. Yes, Malad. And now the air condition coach attendant and air condition coach mechanic. But during the halting period, Malad, they are overstaying in the train. Nobody has taken as a reliever in respect of that. The exact issue, my lord, we have discussed the decision of the Bombay High Court and the Central Tribunal in our original application. The same issue has been decided. The tribunal has granted the extension of benefit of this order. Now, my learned pen is relying upon the decision of the principal bench. It has not been assailed before the High Court or it has not been assailed before the Supreme Court. Whatever benefit the tribunal has granted, it has been affirmed by the Honorable Supreme Court. Therefore, the same issue, my lord, these petitioners, and they are the ACCM and ACCA, they are relying upon the same decision and paid before the tribunal for extension of the same benefits, my lord. The tribunal recorded the findings and tribunal has passed an order by passing a regional speaking order, my lord. They can examine my claim and they can say whether we are entitled or not. But I am placing the operative part of the tribunal's order, my lord. The respondent in terms of annexure A1 to the present way are directed to take a decision past examine our claim and past a result by relying upon the decision of the Bombay High Court and the Supreme Court. The tribunal recorded the findings, my lord. Yes, my lord, paragraph 7. No, sorry, my lord. Yes, my lord. Kindly come to internal page 4 of paragraph 2(1). The tribunal is well considered the order. The tribunal is considered the provision of rule 1502. In para 9 of the order, it has recorded the findings in para 13 that when the train holds, the respondent are actually guarding the train and also helping the subordinate staff in carrying out the maintenance operation. Internal page 4 of the impugned order. Therefore, it is that during the whole period, the staff is working and therefore they have been rightly held entirely to overtime allowance. The terminal record is the findings of the order of the Bombay High Court. Thereafter, my lord, they have assailed the matter before the Honorable Supreme Court, and the Supreme Court dismissed their special petition. Therefore, my humble and respectful submission, my lord, the tribunal recorded that findings and directed the respondent to grant to pass on speaking order regarding whether we are able to get or not. Because the same railway board has implemented the said order. My lord has heard out the matter last 3 occasions at length, my lord. They are trying to establish after the train reaching the destination, we have no work, but we are in a train. No reliever has come to take over the charge. That is why the Bombay High Court has said, yes, that whole period we are able to get the overtime allowance, my lord. That is recorded in para 2.1 of the impugned order, my lord. Paragraph 2.1 in the
There is only a direction to consider the claim.
Yes, ma'am.
Challenge.
Calcutta bench, my lord, cat, my lord, same issue, my lord, dismiss the my lord, OA, my lord.
You
My lord,
decide it.
my lord, already principal bench, my lord, dismissed, my lord. And my lord,
Principal bench, after principal bench, Supreme Court and High Court has decided, forget about principal bench. They have directed you to decide it only. Why challenge it? There is no direction.
Yes. Grateful, my lord.
Whether
I need 6, my lord, next week, my lord.
tomorrow, why?
My lord, Mr. Rai is leading the matter.
After arguing, you are submitting.
Yes, not this.
What is there? It's just a direction to consider. Mr. Rai has not appeared earlier. So he has appeared. Ask him to be here tomorrow, not today. Not today. It's
Item number 20.
The Lordship, Mr. Bajaj is appearing in this matter. Last day I've taken adjournments due to, as he has severe back pain, but today he's still not well. His doctor is instructed him that to take rest and he couldn't come to court. Will Lordship kindly adjourn this matter for this week?
Lord, this is, Lord, I believe, Lord, third time, Lord, adjournment. Lord, my Lord.
round of illness you want us
No. Lord, initially, Lord, no ground of illness is there, but time has been taken. Now, Lord, illness. I am not objecting.
Yes. Has prayed on the ground of illness of the
For 21.
May I please, Your Lordship, I'm for the bid.
I appear for the respondents with Rumen.
My Lord, may kindly come to page 144. This is the advertisement pursuant to which the petitioner applied for Group D post. But you got it. Page 144.
What has the tribunal directed?
Directed that he should be placed in the replacement panel. He was in the original panel. Well, this is the circular of replacement panel. May I hand up to your lordship? And it circular of replacement panel. একটা কপি ছিল যে এই যে
Employment notice is of which year?
2012.
12.
Yes. I have handed over to your lordship the circular regarding replacement panel. Last paragraph. Roman III, Roman 3. Replacement panel shall include only such number of reserved, unreserved candidates as have not turned up as per original panel. I was already in the original panel. Then I filed review, my lord. If your lordship kindly turns to page 203.
So in 2012, you came out with the employment notice. They
Yes.
qualified all the rounds.
All the rounds.
They were medically examined also.
Also,
but then you did not give any appointment.
They did not. Waited for 2 years. They
Yes.
did not. But my humble submission, first offer of appointment, then medical, then appointment letter. They did not give me any offer of appointment. They straightway sent me for medical. I don't know for which post. Then they kept silent for 2 years. I approached the London Tribunal. Then, my lord, again they sent me for medical without making any offer of appointment. They kept mum. Then I approached the London Tribunal. The London Tribunal directed them to consider my case and pass an order. They passed the revision order. They say that I applied for certain posts which are not in A2 medical category. And I am
which are not in
A2 medical category.
A2.
A2.
You are
A1.
in B2.
No. Their medical categories A1, A2, B1, B2, B3, C1, C2. I did not apply for A2 category. I applied for, my lord,
B2.
Not only B2. If your lordship kindly turns to my application, page 182. I applied for 1, 3, 9, 11, and 16. 182.
Oh, so what the tribunal has finally done?
Yes, my lord.
What has the tribunal finally done?
Tribunal has held that he should be placed in the replacement panel. I am in the original panel. I cannot be placed in the replacement panel. Saying, then I filed review, stating that I am already in the final panel.
Which panel? Which year's panel?
2012 panel.
That is over. There was no appointment. Where's the question?
No,
of
no,
that?
from that the medical was conducted for that.
Medical was conducted, no appointment done.
No, others have been appointed.
For you, no appointment done.
Yes.
So therefore, it did not operate to your stage.
Yes.
You were not offered any appointment.
No, offered, but I am sent for medical.
Correct. So after medical, you were not appointed.
Appointed because they say you are considered against the post of A2 medical category, which you are not fit, found fit.
Whatever it is, you did not challenge anything at that point of time.
Yes.
Where is the order passed there?
They are directed to consider my case. They pass this
Where is that direction?
earlier case.
Yes, show us.
Earlier round of case. Those you kindly come to page 171, my lord. Page 71. They pass the speaking order.
No, no. Where is the order of in OA 1053 of 2019?
Yes. 053. Only direction was given to consider.
Where is it? Let us see.
That order.
So for the 2012 panel, you moved in 2019.
No, 19 I was called. 19 was I was called for medical. They kept silent again.
That is the second medical, please.
Second medical,
We are asked.
there was stay by the learned tribunal.
First medical was in 2012.
No, 17.
So after you were selected in 2012,
12 is the notification. Thereafter, selection was conducted.
up to 17.
17.
17, you were placed in the panel.
I was placed in the panel. I was
medically examined also.
Also.
Then what happened?
There was stay by the learned tribunal. They did not proceed. Again, 2019, they called me for medical examination.
So the tribunal, finally the tribunal proceeding was over.
Yes, by the time stay was vacated.
And then you were called for medical.
Medical.
In 19.
Yes. Then my lord.
No, you have been subjected to medical twice.
Twice.
So when was the first medical? You are not telling us.
Yes, first medical. Okay.
First medical was 2014.
14.
2014.
14 first.
Then,
first 14.
then the entire recruitment process was
Start
failed.
from this.
No.
That is
We'll start tomorrow. We'll take up this one.
14, then my lord, I was called for medical.
This will be the first case.